everyone. I'm Larry Boris, the Executive Director of the National Association of Worksite Health Centers. I want to welcome you to one of our series of educational offerings on the FTC's new non-compete rule and evolving state laws, and particularly the impact on worksite health centers. And we're pleased to have two of the partners from Craig DeVault in Indianapolis. We have Stephanie Eckerly and Amy Adelaide. I'll have them introduce themselves momentarily and the topic. This is one of a series of monthly programs we have. And we also have what we call First Monday Roundtables, where we talk about a variety of open topics and invite people to submit their comments, questions, and their sharing experiences as well. Excuse me, all of these programs are recorded, and the slides will be available for NAWIC members on our website. So with that, I want to turn it over to Stephanie. If you have questions during the session, please put it in the chat box, and we'll try to reach all of those. As well, at the end of the program, we'll ask everyone who's still on the call for any comments or questions that they might have. So Stephanie, turn it over to you, and thank you again for you and Amy leading this session today. Have a good day.
Great. Thanks, Larry, and thanks to the National Association of Worksite Health Centers for having us today. So today we're going to be talking about the FTC's new non-compete rule and also touching on evolving state laws, as both of these will impact worksite health centers, both providers and employers. So before we get started, we always have to state that this is not legal advice. So if you have specific legal questions, please consult with your own attorney, or feel free to contact Amy or I after the presentation. And just a little bit about us. Slides are moving. There we go. I am with Craig DeVault, and so is Amy. We're a law firm based out of Indianapolis, Indiana, but do work nationally in this area, and I'm the chair of our healthcare group. I work with a lot of the worksite health centers, providers, pharmaceutical companies. We're on the vendor side, but also work with employers when they're deciding, for example, whether to have an on-site center or looking at transitioning vendors, which is one of the things we're going to talk about today. And Amy, if you want to give a brief overview of yourself.
Sure. Good afternoon. I'm Amy Adelaide. As Stephanie said, I'm also a partner at Craig DeVault. I work out of our Carmel, Indiana office and practice in the area of employment law, both advising clients daily on HR-related issues and also handling employment litigation for clients as well.
Thanks, Amy. So today, we want to talk about, why we're even here today and why this matters. We're going to talk today about the type of restrictive covenants and the impact on worksite health centers, an overview of the final FTC rule and key definitions. Amy's going to touch on FTC's jurisdiction and what type of entities it has jurisdiction over, exceptions to the rule, some pending litigation, which we'll get into whether we actually think this rule is going to happen or not. And then we're going to talk about some state issues too. So the different types of restricted covenants we see are a few. One is non-compete clauses. So this is going to be the majority of our presentation today, talking about those. But another really important one, especially within the worksite health center space for both employers and vendors to consider, is non-solicitation clauses. So whether an employee, a physician can solicit your employees, your vendors, the patients, and talk about how that really crosses over with state law, especially when it comes to patient solicitation and what is allowed and actually required now under a lot of laws. And then we'll talk a little bit about confidentiality clauses, and then just one other type of restrictive covenant we see that we kind of classify too as protection of IP. So why does this matter today? Why are we talking about this in the context of worksite health centers and not just employers and providers in general? One of the big things we see that this impacts is transitioning worksite health vendors. So whether you're with one vendor and you're moving to another vendor that just does worksite health clinics, or maybe you're moving from an on-site clinic manager to a local county hospital or vice versa. if there is a restrictive covenant, this could make an impact on how that transition works. And that includes restrictive covenants both in a clinic management agreement, but also with your individual providers and physicians. This will impact your ability to hire healthcare providers from vendors, practice groups, and healthcare systems and other employers. There may be a physician in your community that you think is amazing. They would be perfect for a worksite health clinic, whether it's an employer-run one or one that an outside company is going to manage, but they may have a non-compete with a health system or a practice group that wouldn't allow them to come work for you. Thinking about the recruitment and investment costs and efforts. So, you know, Amy and I are more on the employer side, but we also work with a lot of employers that are owned by providers. So we see people that love the new FTC rule and do not want non-competes, but we also have a lot of employer clients and provider clients, clinic managers that really do want to have some type of restrictive covenant included because they're putting a lot of money into recruitment and training of their staff. And so they want to make sure they can protect that investment. Of course, protection of your proprietary information, especially within this industry, can be quite competitive, although a lot of that can be done through confidentiality clauses. Of course, this will impact your contractual language. Another one, Larry, I know we've talked a lot about this one within NAWA too, is the notice period for termination of a vendor. So if you are transitioning a vendor, if there are non-competes, you know, and transition clauses, this can really impact how long you want to give notice to your vendor or the implementation time that it will take to bring on a new vendor. And then one of the most important that I think is sometimes overlooked when we're thinking about non-compete clauses is the continuity of care for providers. So we're for patients. So we're going to touch on that a little bit at the end of the presentation. Let's see here, Amy.
Yep.
I'm going to take over.
Sure. So let me give first just an overview of the recent final rule that was announced by the FTC, in essence, banning most non-compete agreements. And we'll talk through the details during our time today as to why I say most. But it's obviously a very significant final rule that's come out from the FTC impacting employers and employees alike. We now know that the final rule is set to go into effect on September 4th of 2024. So it goes into effect 120 days after it was published in the Federal Register. So we'll talk about, as Stephanie said, the legal challenges that have already been filed in response to the federal rule and what the status of those is. But barring any court action stopping the final rule from going into effect, it will go into effect on September 4th. The rule asserts that certain non-competes constitute unfair competition under Section 5 of the FTC Act. And we'll talk some more about what unfair competition means under the final rule. Keeping in mind that essentially the final rule prohibits new non-competes for employees after the effective date of the final rule, and that includes everyone. So that includes your senior executives, which we're going to talk about in a minute, because there is an exception for agreements that are in effect now with senior executives. But once the final rule goes into effect, those will no longer be, you can no longer enforce new agreements or can't enter into new agreements with those senior executives either. But we'll talk about some exceptions that there are still in place, even under the final rule and outside of those senior executives. So the final rule begins with a definition section. And if you search for the final rule, you will find a 500 and some page document that the FTC produced that has all of the comments and explanation and so forth. The actual rule is buried within that 500 and some pages, is about 10 pages long. So I would encourage you that if you really want to read that rule, reach out to us, and we can point you to where it is within the 500 and some odd pages, which you probably don't want to read all of. Although they are helpful in terms of understanding certain aspects of the rule, and if you have questions about certain aspects. So the definition section of the final rule defines what is considered a non-compete clause, and we'll walk through each of these definitions in a minute. Who is considered a worker that is covered within the final rule? Who is a senior executive? As I mentioned, there is an exception for non-compete agreements with current senior executives, or those with whom you would enter into an agreement with prior to the effective date of the final rule. So prior to that September 4th date. And it also contains a definition for policymaking authority. So those senior executives who are excluded have to have policymaking authority, and we'll talk about what that means or how that's defined under the final rule. Okay, so our first definition is, what is a non-compete clause? The FTC rule says it is a term or condition of employment that either prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the U.S. with a different person where such work would begin after the conclusion of the employment that includes the term or condition, or operating a business in the U.S. after the conclusion of the employment that includes the term or condition. A couple of points I'll make with respect to this definition, and the first one is there on the slide, is that the definition of a non-compete does not specifically mention non-solicitation provisions. If you read the commentary within the final rule, the FTC says, okay, it may not specifically identify non-solicitation provisions, but the question would be, is a non-solicitation covenant written so broadly such that it functions to prevent a worker from working for a competitor? So that's something important to keep in mind. I think most people are, taking the position or reaching the conclusion that a non-solicitation provision wouldn't be banned by the FTC final rule, but just keep in mind that it does say a provision that functions to prevent a worker from working for a competitor. So you want to think about how broad that non-solicitation provision is. The other point I want to make about the definition of a non-compete clause is, notice that it doesn't prohibit agreements that restrict competition during employment. And certainly a lot of times we have state laws that do the same thing, right? There's a duty of loyalty, certainly in Indiana, to your current employer, where you can't be engaging in certain competitive acts. But similar to that, this non-compete definition only restricts covenants that where you'd be competing after your employment ends. So important to remember that as well. Next slide, Steph. All right, a worker. The FTC final rule specifically defines who are the workers who are included within this ban. And the point I will make here is that it's an employee, but it's also an independent contractor, an extern, intern, volunteer, apprentice, or sole proprietor who's providing a service. So I think that the takeaway there is, we're not just talking about employees, but also independent contractors as well, who are included within the FTC final rule. The next definition within the final rule is a senior executive. So as I mentioned, the final rule allows non-competition covenants with senior executives if that covenant is entered into prior to the effective date of the final rule. So we have to dig into, well, who is considered a senior executive under the final rule? There are two requirements. Number one, that senior executive has to be making more than $151,164, to be precise, in a year, and also has to be in a policy-making position. And the rule, of course, goes on to explain, well, what is a policy-making position? And it says it's one where the individual has final authority to make policy decisions that control significant aspects of a business entity and does not include authority that's limited to advising or exerting influence over such policy decisions. So as you can see, it's a pretty high standard that has to be met in terms of that policy-making authority to qualify as a senior executive. So examples of individuals who are likely to meet this senior executive definition would include, C-suite executives or partners within a business, such as, physician partners in an independent medical practice, that sort of thing. So that's just kind of an overview of who's included in the senior executive worker definition. I would encourage you, if you're considering taking the position that you have a non-compete with a senior executive worker, or if you yourself have one, I would dig a little deeper into the FTC's explanation as to who is covered and so forth, so that you can accurately understand what's the likelihood that this agreement falls within that senior executive classification. As I said earlier, keep in mind that even with respect to senior executive workers, new agreements cannot be entered into with those individuals after the final rule goes into effect. Sale of business. So the final rule also contains an exception for the sale of business context, and says non-competes remain permissible in a sale of business context. The other thing that I would encourage you to think of here, though, is that even though the FTC final rule says you can still have non-competes in a sale of business context, you need to then look at applicable state law to see what does a particular state say about non-competes in the sale of business context. So you're reverting back to state law for that analysis for a sale of business.
Amy,
oh, sorry, go ahead.
There was just a question here. Can you real quick, before we go any further, give an example of what the difference is between a non-solicitation clause and a non-competition clause, just so everyone knows exactly what you're talking about? Sure.
So a non-solicitation clause is essentially one that says, well, one of two things typically. Either one, it prohibits you from soliciting business from customers or patients with whom you had a relationship while you were with your previous employer. So that would be a non-solicitation of patients or customers provision. The other type of non-solicitation is a non-solicitation of employees. So a restriction that says, when you leave our employment, you can't solicit our employees. And really, under both of those types of non-solicitation provisions, you're going to need to look at applicable state law. For example, in Indiana, there are, with respect to non-solicitation of patients or clients, you have to consider, well, did I have to at least have some interaction with that patient or client? And can it apply to past patients or clients, or can it apply to prospective patients or customers? So even within those, non-solicitation of customers or patients, you need to consider applicable state law. And the same with non-solicitation of employees. Again, for example, in Indiana, we now have case law that says you just can't have a blanket rule prohibiting solicitation of employees. It has to be only with respect to employees where there would be some sort of unfair competitive advantage if you were to be able to solicit them. So that's the definition of a non-solicitation. It's restricting certain solicitation activities, not saying you can't work for a company within this area for this period of time type of restriction, which is what we mean when we talk about a non-compete. I see the other question there in the chat about how they got to the $151,164 figure for the senior executives. And I'm not sure. I haven't looked into how they came up with that dollar figure for the senior executive exemption. I can certainly look into it and update the group, but I have not researched the process they went through to reach that number. All right. I think we're back.
We're right here. Sorry about that.
Right here. That's okay. So let's talk about jurisdiction, because as I said earlier, while the final rule certainly applies to many employers and employees, it does not apply to all employers and employees, which is really important to understand, particularly in the healthcare space, because certain employers and industries are outside the jurisdiction of the FTC. For example, nonprofit organizations, banks, insurance companies. Oh, Steph, we're on the wrong slide now. We should be one ahead of there. There we go. That's okay. Insurance companies and air carriers all fall outside of the jurisdiction of the FTC. So this new final rule does not apply to those entities. Of real importance there for a lot of entities in the healthcare space is nonprofit organizations. Many hospitals are nonprofit organizations. Now, what the FTC has said in its commentary within its rule is, just saying you're a nonprofit entity may not get you out of our, outside of our reach or outside of our jurisdiction, because they have said, first of all, if you're, kind of a sham nonprofit, a sham charity, we may still try to assert our jurisdiction over you. The other thing that they've said is, just because you're claiming tax exempt status as nonprofit may not mean you fall outside of our jurisdiction if you have members that operate for profit, or the nonprofit is operating for the benefit of for-profit members. So again, there is more explanation of that concept within the commentary to the rule, but a pretty large exception to coverage of the FTC rule, certainly when we talk about nonprofit entities. There's also language within the rule that it may not apply to certain state and level government entities when they're engaging in state action. I've looked into that a little bit for some clients and have yet to find an example where a state or local government would be somehow excluded from this. Although I will say I'm not sure that I've ever seen a state or local governmental entity with a non-compete. So a little bit interesting there, and maybe not all that relevant, because they don't tend to have non-competes. The next part of the rule that's very important to be aware of, and I think this is where employers should start thinking about this rule and actually taking some action, some planning steps, I should say, is with respect to the notice requirement. So the final rule requires notice of non-enforcement by the entity to individuals with whom the entity has a non-compete. And in fact, the FTC provides a model notice and even has a safe harbor for employers that use this model notice. So I would encourage entities that need to prepare a notice to actually use the notice provided, the sample notice provided by the FTC, due to that safe harbor. So the notice has to identify the parties to the non-compete. The rule explains how the notice can be delivered. Also explains that if you don't have the individual's last email address or phone number to send a text, that you're relieved of the obligation of sending the notice. I find that pretty unlikely that the employer wouldn't at least have their last known information such that they could send a notice. But this is the area, like I said, where I do think employers should begin preparation for the new rule, because these notices must be sent as of the date that the final rule would go into effect. So by September 4th, these notices would have to be sent. So step one I recommend employers take is create a list of all of your non-compete agreements, right? Take inventory as an entity of all of your non-compete agreements with individuals, so that you know what that body of agreements looks like. And then number two, go ahead and prepare the notice that you're going to use, and get ready in the event that these notices do have to go out prior to September 4th of this year. All right, I'm going to talk for a few minutes about three of the lawsuits that have been filed challenging the final rule, the FTC's final rule. As I said, there are three lawsuits that have been filed, and I'll talk briefly about what the arguments are that are being made in these lawsuits. So the first one, Ryan LLC versus FTC. This is a lawsuit that was filed in the Northern District of Texas. And essentially the entity that filed the lawsuit argues as follows. One, they estimate that around 30 million employment contracts exist that have non-competes in them. And so talk about the huge task for employers in preparing notices for 30 million individuals within this short period of time. They also argue that the FTC's authority is procedural authority and not substantive authority, and that by issuing this ban, really the FTC is engaging in substantive activity, not procedural activity. They talk about in the lawsuit that what does it mean that non-competes constitute unfair methods of competition, and argue that phrase is really unintelligible. What does it mean? They also argue that the ban violates the U.S. Constitution's restriction on delegation of legislative powers, saying that the FTC can't create laws, and that by issuing the final rule, the FTC is creating a law. They cite to the freedom to negotiate contracts. They talk about the fact that states, a lot of states, most states allow non-compete agreements and have applied a case-by-case analysis to non-compete agreements that is working or has worked for a long time. The second lawsuit was filed by the U.S. Chamber of Commerce versus the FTC. This one was also filed in Texas, in the Eastern District of Texas. And in this lawsuit, the plaintiff points to the investment that employers make in their employees because of non-competes. and say that employers may be less likely to make an investment in training their employees and sharing information with them if the employee just has the ability to leave and take all of that information with them. So they talk about the benefit to both employers and employees of having non-competes. They also talk in the Chamber of Commerce case about the fact that states have very well-developed bodies of law addressing this issue. They talk about the fact that Congress, while Congress has considered issuing non-compete bans, it has not. And so by doing so, the FTC is doing what Congress has not and is actually legislating. The U.S. Chamber of Commerce case also talks about the fact that this FTC rule is retroactive, right? It doesn't just apply to agreements entered into after that date, but rather enters in or applies to agreements entered into prior to that date, with just the senior executive exception. The U.S. Chamber of Commerce case also questions the timing. Why all of a sudden is the FTC taking this action, and in fact suggests that it's a political directive from the president, and therefore improper that the FTC is taking the position that it has this authority, when in the past the FTC even itself has said it doesn't have the ability to issue substantive rules. Much more certainly in both of those cases. The third case, the ATS Tree Services case, is a case that was filed in federal court in Pennsylvania. Similarly, in that case, the plaintiff is saying the FTC doesn't have the authority to issue legislative rules. Congress has declined to outlaw non-competes. They're valuable to employers because they encourage employee training. They point out that non-competes are legal and regulated in 46 states, and suggest that employees are competent enough to make their own decisions as to whether they're willing to enter into a non-compete and take a job where non-competes are in place. So certainly the lawsuits are a very pro-employer position, because those are the groups trying to argue that this shouldn't be enforced. Let's move on to the next slide. So in terms of, and this kind of goes to the other side of the argument, and offers comments that the FTC received in terms of why non-competes should be banned. And so you can read fully through these examples at a later time, but essentially in the first sample here, the physician says, physicians who have non-competes often have to abandon the communities where they serve patients because of the existence of non-competes, and that healthcare providers feel trapped by them, trapped in their current employment situation, because they would have to, relocate a far distance away if they were to try to get out of their non-compete, and mentions burnout that can be caused by some employment situations, and physicians feeling like they have no out. The second example here, the physicians talking about the fact that they had a non-compete that remained in effect even after a merger with an entirely different healthcare system, and is arguing that that's unfair, and that their only recourse is to give up their medical practice in any place where they're currently licensed to practice, which in turn harms patients and the physician themselves. And the next slide has one more example where a primary care physician said, I had to commute for an hour to be outside of their non-compete radius, and due to the non-compete, patients who needed treatment didn't get care for over a year because they didn't want to find a new primary care physician. And again, arguing the side of why non-competes shouldn't be permitted and enforceable. All right, so next we have the FTC's position on what it thinks will be the impact of the final rule. First of all, the FTC estimates that there will be a significant reduction in healthcare costs. This is one of those areas where I'm not sure, again, why the FTC is taking that position. I don't know if it does somehow relate to physician availability in certain communities, particularly in rural communities. I've yet to find an explanation for why they're taking that position or making that argument. Next, the FTC says that the prohibition of non-competes will result in a 2.7% increase in the rate of new firm formation. So essentially, new businesses being created. Also believes it'll increase the number of patents. So they're analyzing the impact on innovation, new businesses, new ideas, et cetera, which they believe will all increase as a result of the ban. And then finally, the FTC is anticipating or suggesting that there would be a significant increase in wages for workers if non-competes are banned. Again, I think it's a little unclear, how the FTC is reaching that conclusion. And certainly the counter to that I've seen is that employers may be less willing to pay for training, et cetera, for workers if that worker is just going to take that training and go to a competitor with the training. And with that, I will turn things back over to Stephanie.
Thanks. And I know we have a few questions that we'll address at the end too. So we're going to talk about what we're seeing in state laws. So we're going to talk generally what we're seeing nationally, and then we're going to give a few examples from the state of Indiana too. So we are seeing a lot more states that are passing legislation limiting enforcement of non-competes and barring them for certain employees, especially, lower wage earners and in some industries. So we'll talk about that in a bit as it relates to healthcare. Most courts do recognize that, you cannot restrict an employee beyond what is necessary to protect the legitimate business interest. So an example of that would be, I'm a lawyer. If I had a non-compete that said I could not work at any law firm in the nation, period, right? That would be way more than what is necessary to protect any business interest. But despite the FTC rule and a lot of the state laws, you were still able to protect your trade secrets and confidential information. So in every contract you have, so whether it's an employment agreement, an independent contractor agreement, or maybe a clinic management agreement, if you're a health system or a clinic management vendor, on-site or worksite health center vendor, with your clients, you should still have a clause that protects your trade secrets and proprietary information. Amy talked a little bit about non-solicitation clauses at the beginning. You can still, if they're reasonable in most states, protect your relationships with customers. So an example of this would be, you may not be able to have a non-compete for a salesperson, but you may be able to prohibit that salesperson from contacting any customers that they worked with in the 12 months prior to their departure. Again, though, you need to be careful that your non-solicitation isn't so broad that it starts to look like a non-compete. And then investment in employee training. So again, if you are paying for your employees to go back to school, to go to expensive courses, there are certain times when you can tie employment to that and have repayment provisions. Those get pretty technical though, so call an employment law attorney that you work with or Amy on those, but there are ways to do that. And then there's other, certain things in different jurisdictions, again, setting aside the FTC rule here, where you may be able to protect the company if that employee has unique skills that they learned through you. But the other side of that is, if that employee has such unique skills that it would be a detriment to the community that they couldn't share those, then non-compete may be enforceable. So, for example, I helped a transplant surgeon once, and basically, even though the health system almost across the board had non-competes because of this transplant surgeon's like very, very niche specialty. They basically agreed to waive it for him because the community, there was one of him in this area. Amy, I don't know if you want to talk a little bit about, protection against cutting out the middleman here and what you mean by that too.
Yeah, I think what that means is, not being able to have somebody else do what you can't do yourself, right?
Yep. Yeah, that's helpful. Thank you. And then let's talk about state laws. So let's say that the FTC law gets stayed. We expect there to be, a court order stating that it's not enforceable. Maybe that won't happen, but that is kind of what I think a lot of employers are betting on right now. Is you still have to look at state laws, Amy said. So when you're looking at state laws for non-competes, you have to look at the duration, the geographic scope, and the scope of activities that are limited. And so for duration, for example, a lot of times you'll see 1 to 2 years is enforceable. Geographic scope, I feel like this keeps getting narrower and narrower based on case law, but also in some states it's statutory. So for example, in Indiana, you could not prohibit a physician from working in any county that the health system or clinic manager had offices in if that physician never worked in those other offices. And then scope of activities. Another example I use is, you can't prohibit the physician from going to a neighboring hospital. Let's say it was a family practitioner, but this family practitioner is leaving the practice of medicine and wants to go into finance. You likely cannot prohibit that family practitioner from doing that. So you need to look at, the state law too in the cases. Oh, excuse me. However, because this is healthcare, you have to also look at the physician rules and regulations. Excuse me. So in Indiana, we had a new law that was passed somewhat recently that a primary care physician cannot have a non-compete agreement. So this is defined as a family medicine doctor, a general pediatric medicine doctor, or an internal medicine doctor. Other specialists are included in this ban. However, I've had specialists who say, I also round on peds sometimes, just generally I moonlight, I do that. Can I not be included? In Indiana, the non-competes that were signed before July 1st remain intact. And we also have new exceptions that if a physician is terminated without cause, their non-compete is waived, or if the contract expires, which again, new language in our law that will be litigated as far as what the meaning of that is. We also have a buyout provision for non-competes that are enforceable. So if you have a non-compete with a pulmonologist or other type of specialist. And then one thing I want to touch on here, and most states have this, we've looked at many, many states on this issue, but again, just included Indiana, is a lot of times in the physician regulations, you will find that the physician has to give notice to patients when they terminate that relationship with them. So if a clinic vendor, for example, relationship has been terminated, let's say that employer decides to take the clinic in-house, they're hiring a different physician, that physician that's leaving with the vendor may still have an obligation to notify patients under their physician rules of professional conduct. But in Indiana, the employer also has to give the physician a copy of any notice about the physician's departure. They have to give the patient the physician's updated contact information and location if requested by the physician, and also give a copy of any records. And so, when you look at this, you need to be thinking about the federal law, the FTC rule, you need to be thinking about general law on non-competes and non-solicitations and restrictive covenants in your state. And you also need to be thinking about specific rules that apply to healthcare providers. And for those clients that we have that are national clients, we really recommend in your employment agreements that you have a state-specific addendum for the restrictive covenant, because what might be enforceable in Indiana is not going to be enforceable, for example, in California or Colorado that have very different laws than us. And so, we always tell employers you can't take a blanket approach to non-competes, especially in the healthcare space. As it relates to worksite health centers, I want to spend just a few minutes on that because we had a few really good questions here. So one of the questions was, what if a vendor is for profit? And there, as we know, a lot of for-profit on-site clinic managers, but contracts with a not-for-profit entity. So maybe an employer that's not for profit. Does the new ruling apply? And this got me thinking of a similar question. And Amy, this is, I think, for you. Can an on-site clinic manager put a clause in a contract with their client? So let's say a manufacturing client, stating that that manufacturing client cannot solicit the physician or employees that worked there for 2 years, regardless of if the manufacturing client is nonprofit or for-profit. That, to me, is outside the FTC rule because it's not in the employment context, but I wanted you to opine on that.
Yeah, I agree. There'd be nothing restricting that from being in that contract. And in fact, I'd advise putting something like that in the contract. And I know there was sorry, go ahead.
But the on-site clinic manager would still have to be thoughtful about whether they could put a non-compete in the physician's agreement. And so that gets a little tricky. I've actually helped employers and clinic managers navigate this. You may not be able to have a non-compete under the new FTC rule or under Indiana law with a primary care physician. So clinic manager can't have it with a primary care physician, but you could have it with your client that says the client can't solicit that physician potentially. Again, correct. Even that would have to comply with state law. So then you have to kind of look at both contracts to see what you can do. And we've had situations where, we've seen clinic managers do that. And with good reason. They're spending a lot of money to recruit and they're investing in these positions. But the flip side of that is if that clinic manager pulls out of the community and that physician cannot be employed by the employer to continue to see those patients, we've seen situations where there is no physician in that community to see the patients then. And so I think there's really good policy arguments on both sides of that as to whether they should be used in the Worksite Health Center context, because we see a lot of transition where one vendor just wants the other vendor's staff to move over, and what does that look like?
On that note, one of the issues you just brought up is public policy, right? Is there a physician in the area who can treat the patients who need treatment? And that actually comes up and recently came up in an Indiana case that was filed up in northern Indiana by a physician who is challenging the enforceability of his non-compete. And one of the reasons the court refused to enforce his non-compete is that very issue, is the impact on the public and the availability of healthcare in that specific specialty to the public if the court were to say this physician can't practice in this specialty in this area. So, one of the things that's important to keep in mind, regardless of whether the ban goes into effect or doesn't go into effect, is, what is the remaining, and certainly assuming if it doesn't go into effect, what are the remaining state-specific protections and rules and not just statutes, but a lot of it is just case law that impact whether a non-compete is enforceable or not. And I know there was another question in the Q&A about in the on-site industry where an operating vendor is contractually engaged, how can an individual employee be considered a competitor to a vendor? And for me, that question goes back to the fact that, even assuming that you can have a non-compete, that we don't have the FTC ban and you can have a non-compete, and you look back to state law, before you can have an enforceable non-compete, assuming that state allows non-competes, there has to be a protectable interest, right? There has to be either a relationship between that employee and patients or customers, such that if that physician were to go to a competitor, that there would be this unfair advantage, right? There has to be a protectable interest, either in that relationship or because that physician or other employee has been provided with confidential information about how an entity runs its business, et cetera. Again, such that if they were to go to a competitor, it would give them an unfair competitive edge. And so we still have to go back to that, what is the protectable interest, and is there one, right? How would this entity be unfairly harmed, or would they be unfairly harmed if this employer could go to a competitor? So you have to go back to that protectable interest standard where, what is the relationship that warrants protecting with a patient, with a customer, or what information does that employee have that warrants protection?
Thanks, Amy. Let's see here. Okay, we're going to take some other questions now, and then I want to just talk about some upcoming events. But here's our contact information if you guys want to ask us anything offline. And then I'm going to go down the list here and see if anyone has any questions. So let's see here. Andrew Ward, do you have any questions or comments? No. Oh. Okay. Bridget, do you have anything else? I know you asked some really good questions. So I don't know if you have any others or just comments.
Thank you. Just thank you very much. Very informative. Very well done, ladies. Appreciate your time.
Thank you. Well, next on the list is Chloe Kraft. She's an attorney with Krieg DeVault who helped out on this presentation a lot. So I'm actually just going to say thank you, Chloe. We really appreciate it. Corey Bird with Marsh McClellan. Any questions or commentary? I know you're in this space a lot, seeing a lot of different things going on. No. Okay. Jennifer Kester, anything? No. It's so easy, just no questions on non-competes. Although I have to say, Amy, when I opened up the rule and saw it was 500 pages, I was shocked. Justin, we have Justin or Michael. Any questions?
No questions.
Okay, great. I hope I say this right. Sanal or Stephanie, any questions? Or Tim? No? Okay, well, if you guys do think of anything, let us know. We're happy to talk offline. And quickly, if everyone would give me just, maybe 30 more seconds, I do want to share with you upcoming events. I'm on the board of National Association of Worksite Health Centers, and we're working hard to plan some great events here for you guys. And those are right here. So if you go to the NAWHC events page, you will see those. We have First Monday roundtables that have been really popular on different topics. A webinar on adding allergy services to your work site. And then one thing I want to highlight here before everyone jumps off is we're having our 12th annual forum that's going to be in person, and it's going to be in Indianapolis, Indiana. So if you'd like to meet Amy and I in person, just, stop by. We will be there, and we would love to welcome everyone to Indianapolis and have a great agenda and some social events planned too. So again, go to the events page and you can register for any one of those there. Well, thank you, everyone. We appreciate your time today.